Hello, Constitutional Law class. This video will supplement our discussion of executive power with a discussion of bicameralism, presentment, and the legislative veto, as well as discussion of the appointment and removal power and an introduction to a discussion on impeachment. So let's first talk about bicameralism, presentment, and the legislative veto. So recall that our constitutional system in establishing the legislative power in the legislature has checks and balances within the legislature itself and then relating to the executive. And those checks and balances, first of all, suggest that the legislative power is invested in the Congress, which is a bicameral legislature. So there is a Senate and a House. For a piece of legislation to pass, both the Senate and the House have to agree on the exact text of that legislation, and then the text of that legislation has to be presented to the executive, to the president, for signature. So what happens if the House and the Senate have different versions of a bill or don't agree on the full text? If they don't finally agree on the exact text of the bill, then the bill cannot become a law. It can't be presented to the president. So that's why you have conference committees between the House and the Senate when there are differences, when there's sort of general agreement on what the legislation should be, but there are differences in some of the precise wording or in some of the details. The conference committee is designed to iron out some of those differences so that one unified text is presented to the president. What if the president doesn't accept what the House and the Senate have presented to the president? Well, the president has two choices. The president can either sign it and thereby enact it into law, or the president can not sign it, which is to veto it and not enact it into law. There's also sort of a kind of middle ground, which is sometimes called the pocket veto, which is the president will sort of just let it sit on his or her desk until the term of Congress expires. But basically, the president either signs it or doesn't. Now, we'll see in a bit when we look at cases on on the line item veto, there were efforts to allow the U.S. president to veto only a portion of a piece of legislation presented to the president. But the Supreme Court has said that under the U.S. Constitution, that is unconstitutional. The president either signs the entire thing into law or doesn't, and therefore it doesn't become law. In the constitutions of some states, including the New Jersey state constitution, there are specific provisions for the governor to have a line item veto over certain kinds of state legislation, and those provisions often have limits on the sorts of things that the executive can give a line item veto over, and they usually include things like certain lines or details in budget resolutions. And the line item veto obviously is designed to be a political tool to kind of restrict the ability of the legislature to add in kind of special pork type projects into broader spending packages or other pieces of legislation that the executive might want to line out. So some state constitutions, it's fine and it's provided for in the state constitution, but not in the federal constitution. Now, you should also note a practice that has arisen in recent decades where presidents will issue a signing statement upon signing a piece of legislation into law. And the signing statement can just be a kind of pro forma thing. You know, we're excited to sign this new piece of legislation into law. We've worked together on it. We think it's important. Signing statements also can put the president's own interpretive gloss on a piece of legislation, and sometimes the signing statement will suggest that a portion of the statute the president is signing is of dubious constitutionality or maybe unconstitutional in the president's view if it's interpreted a certain way. So the executive will say, I am signing this, interpreting this piece of the statute in such and such a way, in the way that I believe is the only way this statute could be construed constitutionally. The effect of those signing statements is really pretty unclear. Some of that will depend on your views of statutory interpretation, but we really don't have a clear understanding from the court about what effect, if any, such signing statements may have. Now, you should note that this idea of bicameralism and presentment is an important feature of our constitutional design, and it is referred to, for example, here by Madison in the Federalist number 51, and this is one of the ways in which there are checks and balances. We have a Senate which is kind of thought of as the more aristocratic branch of the legislature, the House, which is kind of thought of as the more populist branch of the legislature, and the executive, and all of them are part of this notion that no one kind of part of society is supposed to be able to dominate entirely the legislative process. So one of the first things we want to think about in terms of executive power in relation to legislation and the role of the executive is the extent to which Congress can control the work of the executive. And this issue really arises with great force in the contemporary period, especially after the New Deal, with the growth of the administrative state. So as we've seen in our Commerce Clause and other cases we've looked at in the New Deal era, the executive branch grows considerably, and administrative agencies within the executive branch grow considerably, both in size and in importance. And Congress really doesn't have the capacity to administer huge amounts of details in some of the kinds of regulatory regimes that it might create. So for example, think of the Food and Drug Administration. I don't think anybody would question the fact that we have to have some kind of legal framework to say if we're having pharmaceutical products, medicinal drugs, they ought to be tested for their safety, for their efficacy, and we shouldn't just let anybody willy-nilly put pharmaceutical products out into the stream of commerce that can be really damaging to public health. So Congress creates a statute, the Food, Drug, and Cosmetic Act, that lays out those broad parameters. Certain things will be classified as medicinal drugs. Those things have to go through this approval process. But of course, Congress can't in detail specify all of the scientific mechanisms that have to be used for every different possible kind of drug that may come up to market, nor is Congress capable of actually administering those scientific tests. So what does Congress do? It creates an agency, and the agency sits within the executive branch, which is the Food and Drug Administration. So the executive branch has the ability, and we'll look at the appointments clause in a little bit. The executive branch appoints the administrators, the officers who will run the Food and Drug Administration, and then that agency creates rules and procedures for the ways in which it's going to implement the desire of Congress to have this kind of testing. So, of course, we can have lots of debates about the nature of these agencies, whether they really adhere to the statutes, and if you take a course in administrative law, you'll get into a lot more detail about how that law works. For our purpose now, note that in general, the court has viewed the ability of Congress to delegate authority to the executive branch in very broad terms. The basic principle is that the Congress cannot delegate its legislative authority to the president, to the executive branch. The Congress is the legislature, the executive branch is administrative and not legislative. But of course, even in the example we just discussed, an agency like the FDA has to make rules, and those rules have legal force. So, why is it that the FDA's ability to do that doesn't violate the separation of powers? And the answer the Supreme Court has given is, well, Congress can't delegate completely its authority to the executive, but so long as there is an intelligible principle in the legislation that Congress creates under which the executive branch is supposed to administer and execute the authority that Congress has given it, that is generally considered to be okay. And that is the Tooby v. United States case kind of articulates this in 1991. Now you should note there continues to be debate about the scope of the intelligible principle doctrine. And there's, as you might be aware, there's a lot of debate about the nature and size of the administrative state, and whether, in fact, the administrative state, as it has grown up since the New Deal, really is sort of fully compliant with the constitutional concept of the separation of powers. And many conservatives argue that the administrative state has gotten too large, too much is delegated to it, and it's effectively creating a sort of fourth branch of government, or giving too much authority to the executive branch. So even the intelligible principle idea has been tested. In a very recent case of this past year, Gundy v. United States, that principle was tested in relation to a sex offender notification statute. So just note for now that the majority of the court reaffirmed the intelligible principle standard and upheld the particular statute and regime that was at issue in that case. But there was a notable dissent from Justice Gorsuch, joined by Roberts and Thomas. Kavanaugh had recused in the case because the case had been, one version of the case had been before the D.C. Circuit when Kavanaugh was on that circuit. And Gorsuch, in his dissent, suggests that the intelligible principle doctrine has really gotten too broad and is kind of untethered from the Constitution. So we'll see. It's going to be one of those areas, I think, of sort of ongoing debate. For now, though, when you see at the most basic level a delegation of authority from Congress to the executive branch, you simply want to ask whether there's some intelligible principle. And there's really been only 2 cases since the New Deal in which the court has ever said that there wasn't, and really in the contemporary period there haven't been, really immediately contemporary period there haven't been any. So it's highly unlikely that a majority of the court would, unless there's a real shift in the doctrine, would find that there's not an intelligible principle.